Sir, before I ask Lord Clarke further questions, you raised a question yesterday about the actual amount paid to the McFarlane Trust in 1989. And we've sought to ascertain what the answer is. So I'm just going to put up a couple of documents and give you a couple more references. These aren't questions for Lord Clarke, and we haven't troubled him with the material. The short answer, and then I'll just show the documents, is that we understand that £24 million was what was paid to the McFarlane Trust, calculated on the basis of 1,200 times 20,000. In fact, the documents show that there were then slightly more than 1,200 applications, and so there was a need for a small amount of further money. Some of that further money was paid out of interest, but there appears to have been one further request, or possibly more, to the government for a small additional sum to ensure that those could be paid. That I think was later in 1990, 1991. The answer to the question of why the earlier materials refer to 20 or 19 million is a little more complicated. It I think turns on how the McFarlane Trust was set up and it envisaged, I think, initially £5 million being utilised from the McFarlane Trust, but that I think proved to be not an option that could be gone down because of the need to set up the McFarlane Special Payments Trust. But we can investigate that in more detail. But the short answer, sir, is £24 million was paid.
Well, I recollect Peter Stevens' evidence about his outrage, as he called it, at the suggestion that £5,000 should be taken out of
5 million.
What was 5 million, sorry, out of the McFarlane coffers in order to pay for what the government had just announced as a further bonus.
Yes, and I'll just show the documents, 3 documents, and give you a 4th document reference, just so that everybody can see the basis for what I've just indicated.
Just to make it clear, before I start being misreported again, this is all after I left the department. This is all nothing to do with me.
Some is after, some is before, but it doesn't require any questioning of you, Lord Clarke. So MACF 602_022. These are the minutes of a meeting of the McFarlane Trust on the 22nd of March 1990. If we go to page 3, and I'm sorry, I don't have that, thank you. So if we look at under the heading Ex Gratia Payment Progress Report, the administrator reported for formal record that negotiations had been completed shortly after the January meeting and the McFarlane Special Payments Trust deed had been engrossed on the 29th of January 1990. A copy of the deed had been sent to all trustees. He further reported that on the basis of the rate of expenditure forecast, the government had paid the full £24 million in a single tranche, and this had been received on the 31st of January. And then, so that shows that the actual sum transferred and the date of transfer. If we then go to DHSC 0003357_015, this is a minute to the, I think it's the private office of the Minister of State for Health, who at that time was Virginia Bottomley, dated the 28th of November 1990. And then we'll see it says, as MSH knows, the McFarlane Special Payments Trust was set up with a grant of £24 million to pay £20,000 to each haemophiliac infected with HIV. At the time, there were an estimated 1,200 such cases, but the Trust now knows of 1,219 potential beneficiaries. The Trust has paid 1,206 from capital and the interest earned on it and is able to pay 2 more. However, it needs an additional £120,000 to cover 6 further payments, which it will be ready to make very shortly. Further funds may be required for the remaining 5, but the Trust has not asked at this time, as 3 applications are still being validated, and in 2 cases there's no contact with next of kin. And then if we look at DHSC 0003357_014, and the last document in the present document post date Lord Clarke's time in office, you'll see there's the confirmation in relation to the additional payment being given by the Secretary of State, so by this time, William Waldegrave. And then there's one further documentary reference there, which I'll read out, but which I don't have available. But I'm reading it into the transcript so that recognised legal representatives as well as you can look at it when it's disclosed. And it helps, I think, understand the position in relation to the 19 million figure and what was envisaged in relation to the 5 million shortfall. And that will be found, but it isn't available for display now, at SCGV 40230_060. I'm just going to check I've read my handwriting correctly. I think that's correct. So I have the handwriting of a doctor. I won't put it up now. So I hope that's a sufficient answer for present purposes, at least to the question that you posed yesterday.
Yes, so the overall picture is that 24 million plus was paid, the sum in effect being calculated as at £20,000 for each of the beneficiaries. That class increased. It's a bit uncertain from the figures you've given what happened to any payment in addition to the 6 or 5 further payments, but it's small money in terms of the overall. But at least you've given us a picture of the sums that were paid. The figures otherwise were a bit confusing.
Yes.
So thank you for that, and thank you for your patience, Lord Clarke, while that was explained.
So, Lord Clarke, I'm just going to then pick up in relation to the HIV haemophilia litigation, some aspects of your remaining involvement before you left office and transferred to a different government post. I'm not proposing to go to the Court of Appeal judgment that was delivered in the autumn of 1990, but I think it's right that there was a hearing in front of a judge and then an appeal before the Court of Appeal about public interest immunity.
I can't help that was after I'd left the department.
Well, I don't think that was after you'd left the department.
I mean, you must make that clear because, I'm beginning to get, allow some of the misreporting of what I've said and attributing things to me in the press, that obviously because being put by journalists who are sympathetic to the victims. But, I have been attacked for the supposed inadequacy of the settlement, which actually had nothing to do with me. I had long left the department and I was Secretary of State for Education by then.
Lord Clarke, I'm not asking about the settlement. I'm asking very, very briefly about the issue of public interest immunity, which arose when
public
you
interest
were
immunity, yes, surely. I'm sorry. Yes,
and if we just look at your witness statement, WITN 0758012.
It's coming up.
It is. If we go to, this is your witness statement, second witness statement. If we go to page 80, please, Shomek. So yes, paragraph 49.4. So we can see this is during your time in office. The Court of Appeal gave judgment for the plaintiffs on the defendant's application for public interest immunity. And then there's reference to an interview that you gave. And then the next paragraph says, I did not play any part as far as I can see or remember in the formulation of the claim for public interest immunity, and I was not asked to sign the PII certificate in this case. I draw attention to that, Lord Clarke, simply so that there is an understanding. We can put the certificate up if necessary. I don't think it's necessary. But the certificate shows Lord Clarke did not sign the PII certificate. It was signed by, I think it's the permanent secretary, but higher.
I think it was about to say, to this day, I don't know what documents we're talking about. But.
I make that point just to explain why I'm not going to be asking you further questions about public interest immunity. I am, however, going to ask whether you want to clarify something you said yesterday. Yesterday, Lord Clarke, you said this in the context of talking about Donald Aitchison. You said that Donald wasn't the sort of bloke who was trying to cover up documents. There are no missing documents. And I just wanted to ask whether you wanted to clarify that. We know, and indeed...
Well, sorry, that's my belief. Firstly, I may gather I had the highest regard for Donald Atchison, and one of the things about Donald was he was very well motivated. I mean, he was completely motivated in his job. He was a very conscientious man, and he had a very strong commitment to public health, public safety, all that kind of thing. He introduced, actually, a much higher priority into the department of actually concentrating on public health.
Just want to ask you to clarify this.
As far as I'm aware, if secretly, for some curious reason, he wanted to hide documents, I remain, again, to this day, utterly unaware of what documents we're talking about, and amazed that anybody thinks anybody like him would have done it.
The question, or the issue I wanted you to clarify, Lord Clarke, is this. You know, I think that there are a number of missing documents, in the sense that there are documents that have not been found. Your own statement refers to that. I understood the point you were seeking to make about Dr. Akerson was that you were seeking to emphasise your belief that he was not part of any process of trying to conceal.
I suspect, like me, he had,
right?
like every other senior person in the department, he hadn't a clue what was being put in the archive. You move on, you're too busy dealing with events, moving on, doing your job. I've never encountered a senior civil servant or a minister who ever spent any time asking what is being archived. I suspect none of us. It is, it's an important thing that departments do, and that departments do it slightly differently. This department did not keep the originals that I had when I had received them, where it's obvious as soon as you look at them that I've read them. So most of the documents I've never seen in my life before. I suspect Donald had no more idea than I did, no more idea than the permanent secretary did, what some junior official was putting in the archive, and they err on the side of quantity. We have thousands, you may be missing some documents, but the document about this inquiry has thousands and thousands and thousands of documents which we're working through.
So is this a correct way to understand your evidence, Lord Clarke? And I'm asking this because I've been asked to
I had nothing to do with what documents were kept and weren't. I'm amazed if Donald ever had the time to get round to finding out what was being archived.
Is this correct? If you listen to the question and then see whether this is a correct summary of your evidence, you accept that there are documents, you acknowledge there are documents that are missing, but you don't...
The only thing I can think of is my ministerial diaries.
Well, there are a number of briefings, other documents that your own statement refers to as not having been made available to you, and that's because no one can find them. Your point, as I understood it yesterday, was to attempt to emphasise that Donald Akerson would not have had, in your view, any connection with concealing.
I don't think any politician or senior civil servant has time to start. You couldn't conceivably spend part of every day going through hundreds of documents saying, archive that one, don't archive that one. Some bloke probably it's his full-time job. They all come flowing into his office somewhere, and he tries to decide what future historians, future generations, as it turns out, future inquiries, might want to see. If you kept every document that circulated in the government department, as I said yesterday, you'd need a tower block for every 2 or 3 years of supply. So somebody quite junior, I have to say, I suspect, I don't know, I've never inquired into the archive system, but I suspect somebody really quite junior does a year or so of the job of putting things in the archive.
I'm going to ask you now to look at 2 documents, a press statement released in your name on the 20th of September 1990 after the Court of Appeal judgment, and a transcript of an interview you gave on that day. I'm going to draw your attention to certain parts of them, and then I'm going to ask you a couple of questions about them. So the press release is RFLT 605. We can see it's Kenneth Clarke's statement on Court of Appeal judgment concerning haemophiliacs 20th...
Remind me what the judgment was about. It was on this PAI application, was it?
Yes.
And which way did it go? Who won?
Well, if we look at the documents, that might become clear. Some of the documents fell to go back for consideration as that they should be disclosed. We'd see, I'll read the whole document so that I'm not accused of being selective. It's an appalling tragedy that so many haemophiliacs were infected by HIV as a result of their NHS treatment. For this reason, the government's quite uniquely paid the victims at least £20,000 each to help with their problems, and we've paid more in cases of hardship. We've made it clear that we will review our expenditure of £34 million so far and top up the funds of the McFarlane Trust if that becomes necessary. In my opinion, on the factual information before me at the moment, this tragedy was no one's fault. The doctors and staff gave the patients the best medical treatment available in the light of medical knowledge at the time. The patients could have died then if they'd not received that treatment. When the blight of AIDS first struck, haemophiliacs suffered the same appalling consequences throughout the Western world. Today's judgment will enable the judge to see a further batch of documents in addition to those already disclosed. I'm advised they do not contain anything which will reveal that anyone was at fault. It may be argued that we should pay compensation to the victims regardless of whether anyone in the health service or Department of Health was negligent or to blame for the tragedy. I believe it would have very grave consequences for medicine in this country if compensation was paid whenever a patient who'd been treated properly by his or her doctors later suffered awful side effects or died. We rely on the clinical judgment of the medical and other professions when patients are treated. This principle of only paying full compensation when negligence is proved is not unique to the case of the haemophiliacs. It could arise over and over again whenever a patient suffers a harrowing experience after receiving treatment. In the USA, the practice of medicine is now dominated by these issues of compensation, and their resources for healthcare cut back as a result. That should never happen here. If at any stage I am advised that there is evidence that this tragedy was probably caused by the fault of someone in the NHS or in my department or in one of its agencies, the government will pay compensation for the victims of that error. If, as I believe, the NHS and the department are blameless, we will maintain the payments to the McFarlane Trust that we have already put in hand to give exceptional help to the victims and their families. So that's the first document. I'm going to ask you to look at
I agree with all that. That remains my view today. In the United States, some of the treatments just doctors won't give it. If they're not insured, they won't do it, or their insurers tell them not to, because there's a chance it will succeed, chance it won't, and they know they're going to be sued if it doesn't. And the practice of medicine in this country now, much more cautious than it was in the 1980s as litigation has grown. Preventative medicine means that it does rather delay the treatment of patients. Doctors now give endless tests before they do things, far more screening and all the rest of it, because they know they're going to be sued if later anything goes wrong, and they'll be accused of not having had an MMR test or something. It's a precautionary medicine. Is I think the description of the extremely litigation-conscious practice of medicine, particularly in the States, particularly here. In some specialties in the States, I remember being told that the actual practitioner divests himself of all his assets. Is penniless. It's all in his wife's name because he can't insure properly, and it's the only way he can stop being sued if he continues to practice in his difficult speciality where there are very considerable risks in the treatment.
If we go to the second document, which is an interview that you gave on World at One the same day, DHSC 0046936_078. You'll see transcript of interview with Secretary of State, Thursday the 20th of September, World at One, and it's in the context of the Court of Appeal having delivered their judgment. I'm not going to read out the whole of this document.
This is like a classic.
But I'm going to... I'm sorry, Lord Clarke?
So it's an absolute classic, isn't it? I must admit, I've been retired for a couple of years, and just getting used to this kind of journalism. It's just bizarre.
So I'm just going to read...
Look at the questions.
I'm just going to read out some extracts of this one and then ask my questions about the two documents. So we can see your answer where you refer to it being a procedural sort of hearing and a technical argument. And then you say this, in my opinion, this is the fourth line of your answer, as far as I'm aware, those documents contain nothing which will help the haemophiliacs establish what I believe to be their mistaken claim. This tragedy was the fault either of the health service or any of the doctors or the licensing agencies at the people against whom they brought the claim. And then if we go down to your next answer, You say, had they struck it out at this stage, the result would have been all that protracted suffering and so on that will be caused if a long legal action results would, of course, have been saved. They are entitled to bring their claim, but on all the evidence... I'm sorry, I've missed out an answer. Shomik, apologies. Could we just... If you leave it on screen as it is, that would be great. So I'll go back to the first of your answers on screen. We're certainly not stringing out the legal proceedings. And our reaction to this tragedy to the haemophiliacs has been to pay each of them at least £20,000 with more in cases of hardship. And we've spent a great deal of money in trying to alleviate all the suffering that has occurred. They are persisting on bringing a legal action, trying to demonstrate that it was fault that gave rise to this tragedy, trying to get much bigger sums of compensation, and we are not able to concede that. And then if we go to your next answer, had they struck it out at this stage, the result would have been all that protracted suffering and so on that would be caused for long legal action results would, of course, have been saved. They are entitled to bring their claim, but on all the evidence and all the legal advice before me, there's no negligence, it was nobody's fault. And we cannot pay up very large sums of money in such circumstances. It would have very grave effects to the National Health Service and for the practice of medicine in this country. And then if we go to the next long answer, but pick it up about 6 lines down, you say, in this case, in my opinion, the people concerned were given the best medical treatment available, the same treatment they would have got from any other part of the world. Their lives were prolonged by that treatment, but unfortunately and tragically a side effect ensued with the result that many of them are now HIV positive and suffering from AIDS. If every time a patient's given the best medical treatment available and then that treatment goes wrong without anybody's fault after everybody has done their best, then the national health system would become like the American system, and you continue to discuss that. Lord Clarke, first question I want to ask, having regard to those 2 documents, so the press release given on the 20th of September and the interview, was this part, as it were, of what we saw referred to as a possible strategy in the documents we looked at yesterday of a public relations offensive, trying to tie the...
I've been invited to give an interview. I'm obviously explaining. So I'd had nothing to do personally with the PII, and I didn't. I don't think I knew then. I don't think I ever knew exactly what documents the permanent secretary had claimed it for. But the way in which things work, the civil servants don't go out. It's the ministers. Some ministers got to go out and explain the department's position. If you have something like this where there's some media reporter wants to report it. So I was explaining the department's position, and actually what you've read out, I've read it, and if it was all contemporary, I would say the same things again. It's just answering a criticism which the journalist is obviously determined to put. I mean, some of his questions are extraordinary, but I forgive the journalist. He's obviously doing his best. He feels very great sympathy for the victims, and he is obviously he's sort of kind of insisting this is all sort of trying to deny them some redress or something. But I think it's all perfectly clear. There seems to be there's one slip that I found a moment ago with the wrong word at one point, but that may be a typing error in the transcript. But it's nothing serious. It doesn't matter. I've done my best in this, and that was part of my job. I'm acting as the spokesman for the department and trying to explain what these preliminary processes, which the lawyers representing the department had advised we should take, and which on these preliminary stages the plaintiffs had won and our lawyers had lost the argument, but they're perfectly entitled to argue it, what actually was about and what approach we were taking. And in particular, I keep stressing all the way through this, if there's any evidence showing negligence, if there's any evidence showing fault, we will pay full compensation, as we always do, and as we always did. And I tried to explain the policy with that, and the fact you can't just pay out compensation in all those cases where there's no fault on the part of the doctors, there's no part on the fault of the health authority, and there's no fault on the part of the department. And that is the theme we're still maintaining. You know, that runs. That's still the approach today, and I think any other approach would be quite impossible. You'd destroy the health service.
Lord Clarke, my question is this. Was this part of an attempt to turn the tide of public opinion and public sympathy away from those victims of what had happened.
No, it
towards
was an
the
attempt
government.
to explain. No, it's not. It's not a particularly campaigning interview. I just said what it was. It was. So this isn't public relations. This is the ordinary, day-to-day business of the government answering questions and accounting through the press to the public for something that's being queried.
It might,
This would. I don't think this would have any dramatic effect on public relations.
it might,
There's too much public relations in politics today. It wasn't like that in the 80s.
it might be thought from some of your evidence yesterday, or it might be said from some of your evidence yesterday and some of the kind of thing that's said in this interview and elsewhere, that you were being critical of the plaintiffs for having the temerity to sue the government.
Now you're altering what I said. Where is it critical of the plaintiffs?
Lord Clarke, can you
Not critical of the plaintiffs? Nonsense.
Lord Clarke, I'm going to ask a question, and it'll be more efficient use of your time and ours if you listen to the question.
Well, they're so long, and it's inaccurate. I actually said at one point in this, they're perfectly entitled to bring the action.
Were you, in your own thinking at the time, critical of the plaintiffs for having the temerity to sue the government?
That's ludicrous. No, of course I wasn't.
If we then...
I've engaged in legal practice for years. If I'm defending a plaintiff or defendant, I don't have contempt for the other side. It's just they're sometimes quite difficult to judge, and the judge eventually gives you a judgment and sorts out.
If we then...
farcical to suggest that.
If we then pick up the chronology of events in terms of your own direct involvement in the litigation at HMTR 601_039, we can see that this is an internal report to the Chief Secretary to the Treasury, so Norman Lamont at that time, dated the 28th of September 1990, and it's in anticipation of a discussion that you and Mr. Lamont are going to have. So we can see it says Mr. Clarke has asked to discuss this subject with you on Monday at 6:30 p.m. The immediate issue is whether or not DH, Department of Health, should signal to representatives of HIV-infected haemophiliacs a readiness to explore an out-of-court settlement. If we go to page 3, and we look at the heading Mr. Clarke's dilemma, it says DH say that the haemophiliacs representatives, possibly sensing that their strength lies in the political rather than the legal case, have indicated in response to the Judge Ognall's statement that they would be willing to discuss an out-of-court settlement. We understand that Mr. Clarke is instinctively disinclined to proceed down this road, while being aware that the government is likely to encounter severe criticism whatever it does. He has not, however, made up his mind and would like to discuss the position with you, especially given the large potential financial implications. Is it correct that you were instinctively disinclined to proceed down the road of an out-of-court settlement, and if so, why?
We got there yesterday, yes, it was plain yesterday. It obviously was. The problem being that it is the real world, the politics of a public, where the government's involved in litigation. A settlement involves agreeing a sum in full and final settlement of the plaintiff's claims. What tends to happen in these kind of cases is when you settle, you agree, as it were, you figuratively shake hands with the plaintiff, it immediately gets denounced as inadequate, despite the fact that the plaintiffs have agreed to it and have accepted it as a full and final settlement. And it gets reopened. And although I wasn't responsible for the event, I had gone by the time eventually the decision was taken to settle it. That, as we all know, as we're sitting here, because that's exactly what happened. The people who claimed agreed, that was it. That was the full and final settlement of their claim. I'm sure their plaintiffs' lawyers explained that to them. They then realised they couldn't take out another writ and try and get some more, so that they tried other ways of campaigning. I mean, I don't blame them. I mean, they are very, very hurt and aggrieved, and they've suffered a tragic experience with either themselves or their relatives. But in the real world, if you're a minister, you have to, particularly in this world, health, you have to appreciate that you're not really, in wide terms, you're not going to win either way. You're going to be criticised, whatever you do.
Can we go to page 6 of the document?
But that's put more clearly in a little less exasperated tone by what you just read out.
We can see the line to take, just halfway down the page. That's the line to take to.
This is the advice to the. I wouldn't see this.
You wouldn't have
this
seen
is Norman Lamont's briefing
It
of
is.
advising him how to handle the meeting with me.
That's right, and I'm not asking you about the detail of this. I want to ask you about
I've
something
never
on the
seen
next
those.
page. Well, you've seen it for the purposes of preparing your witness statement, Lord Clarke.
And they obviously were inclined to agree with what they thought I was going to say to them, which is why I did. There's no point in settling.
Thank you, Shimmick. What I wanted to ask you about is what's said at paragraph 12. I was just showing the previous page to put it in context in the document. Mr. Clarke is understandably anxious to minimise the amount of paper written on this subject and to restrict circulation of any such paper. That is why I'm not copying this minute widely. Why were you anxious to minimise the amount of paper written on this?
Because another problem arises, it's worse today than it was then. If, in the end, we started negotiating with the other side about what is a suitable sum, what reflects the risks of the litigation, the strength of the case and all that, it's quite hopeless if when you discuss how much you might, what you're going to offer, what you think the other side will go, it all starts leaking to the newspapers because you've got somebody on the inside who decides they want to help the other side. Most lawyers, if you anybody who does any negotiating, once you entering into, or you might enter into a negotiating process, the last thing you want is everybody in the office having a piece of paper telling them exactly where you are, and some idiot starts leaking it all, and you can't proceed. You're completely undermined. It wasn't to hide guilty, incriminating documents or anything of this kind. And if you are going to have and it didn't stop this briefing being written, but it perhaps wasn't circulated as widely as it otherwise would have been. People need to know. We obviously have to have documents. You obviously have to record what you're doing, but that's all that means. So let's take particular steps to make sure that people who don't need to see it, because the whole thing would reduce to a farce if our discussions of our negotiating position start leaking, and it will be just completely undermined.
Then the upshot of the meeting appears to be set out at HMTR 601_042. Again, this is an internal Treasury document addressed to Mr. Lamont. The position we reached during and after the discussion with Mr. Clarke can, I think, be summarised as follows. The government has to choose between trying to negotiate an out-of-court settlement and letting the court case proceed. I'm not going to ask you about the detail of what's set out in terms of advantages and disadvantages. If we go to page 3, paragraphs 8 and 9, on the above analysis, the strategy of eschewing negotiation and letting the court case proceed looks to be clearly preferable, certainly from the Treasury point of view and probably from the point of view of the government as a whole. You may like to run through the analysis quickly with Mr.
Yeah, Norman and I seem to have wound up agreeing.
So the strategy, is this right to understand, at this point in time, as agreed between you and the Chief Secretary, is simply to defend the court case?
Yes, which would settle, of course, if we got a judgment from the court, when they would have had many more witnesses who, people weren't dead then, and it was much nearer the events. Had you had a court judgment, that would have given the most authoritative decision on was it the fault of the doctors or the department, or was it not? We wouldn't be, obviously we wouldn't be here today. There wouldn't be this argument would have been resolved decades ago. Had it gone to court, had we had a judgment, I mean, no doubt some people could have gone to the Court of Appeal, or as fit, but when you've got a final judgment, that would have settled it. That people do accept the authority of the courts. The court would have decided fault, no fault. And we'd, as it happens, with hindsight, I'm rather going back to my original view. It would have saved an awful lot of time, money and distress and years of debate.
And then if we then move on towards the end of October to the position shortly before you leave office, or leave this office, HMTR 602_002.
Had we won the court case, I'm absolutely certain we'd have given more money to the McFarlane Trust. Again, that would have been for, to get across to the public that we were not, triumphing in victory, but the position had been resolved. We still felt sympathy, still give such financial help to alleviate the problems as we could.
If we look at this document, it's dated the 23rd of October 1990. Again, it's an internal Treasury document, and it records as follows. The Chief Secretary spoke to the Secretary of State for Health over the telephone yesterday afternoon, so that's you and Norman Lamont. They agreed that there were no grounds for offering an out-of-court settlement. Department of Health lawyers had indicated that a settlement might be achievable at around £50 million, but once negotiations started, it would be difficult to stick at this or any other figure. Mr. Clarke suggested, however, that if the other side made an offer of 20 or 25 million and DOH lawyers considered that it included a watertight guarantee that the writs would be dropped, this would represent a good settlement. The Chief Secretary expressed the view that a settlement at that level would be highly unlikely and would certainly have to be entirely at the initiative of the other side. He felt that it would be far more satisfactory to win the case in court and then make a moderately generous offer.
It shows that at the time, had we won, the Treasury, and he was the Treasury Cabinet Minister at this stage. He's not Chancellor, he's Chief Secretary, I think, and he's the man in charge of government spending. He controls the purse strings. Even the Treasury, if we won, we're just expecting, as he put it, to make a moderately generous offer on an ex gratia basis. That was Norman and I. That is what we at this meeting would have preferred to do. I mean, I'm relying on the document, but the more we go on, the more I'm just not surprised. As it happens, my judgment today is it's a perfectly sensible position for the two of us to take up.
And then just reading on for the sake of completeness, Mr. Clarke agreed with the Chief Secretary that the government lawyers should be instructed not to make an offer themselves under any circumstances. Over the page, Mr. Clarke then commented that some of the cases against health authorities were very strong and were in fact straightforward medical negligence cases. The Chief Secretary agreed with Mr. Clarke that it would be important to present those as negligence cases indistinguishable from any others. The Chief Secretary and Mr. Clarke agreed that they would not seek to raise the issue at Cabinet. Mr. Clarke did not raise the PES issue. Do you know what that's a reference to?
I can't remember what that means.
Is it fair to understand from this document then that this represents the position that you and Mr. Lamont had reached by late October 1990?
Well, it obviously does, yes.
And then last document on the issue...
This is only about a month before I left the department.
I think it's actually just a week before you left the department, probably. But
it was the week before I left the department.
I think so. I might have got the date wrong. Last document on the litigation, Lord Clarke, DHSC 0046962187. This is an internal Department of Health document, present position on HIV haemophilia litigation. We go over the page, bottom of the page. This is just to complete the picture factually, Lord Clarke. Kenneth Clarke met counsel on the 1st of November to discuss this. The line was confirmed that there should be no offer from the department. However, our counsel would make known to the plaintiffs that if they were to offer a settlement around 20 to 25 million plus costs, this might be considered. Any settlement would have to be acceptable to all plaintiffs and end the litigation. No money has been agreed with Treasury for an out-of-court settlement, and this could be difficult to obtain as the prospects for successfully defending the action are reasonable. So that would appear to be your last involvement, Lord Clarke.
I mean, the background to all this is our lawyers, which is the most important thing, but I think I as well. I think my lawyers and I are reasonably confident that if it was fought through, we were going to win this. In my opinion, the approach being taken by the plaintiff's lawyers makes it perfectly clear that the victims' lawyers also felt pretty certain they were going to lose if they insisted on fighting this, which is why they were approaching us, making offers to settle. So we didn't want to take too tough a line with them, although Norman and I thought the best thing was to sort out liability and stop the argument about whether there was fault or not, and then start giving them money on an ex gratia basis, because he, like me, I'm sure, felt the same humanitarian instincts as everybody else of sympathy for the victims of a dreadful tragedy.
Now, according to the dates given in your statement, this would have been, in fact, your last day in office at the Department of Health, 1st of November, and you then moved to the Department of
Yeah,
Education.
well, just to make it clear, it's true of the other funny gaps, you know, the delays in responding to documents. You just can't remember what political mayhem was taking place in the background. This is about the time that Geoffrey Howe resigned from Margaret Thatcher's government, and so Norman and I were still trying to get on with the business of the day and having a meeting when all hell was let loose on the political world, and Parliament and so on, which obviously Norman and I, as members of the government, also had to inhabit.
Now, you were succeeded by William Waldegrave as Secretary
That's
of
right.
State for Health, and so you were then not the government minister dealing with the process of the actual settlement.
I had nothing further to do with it,
Right,
as far as I can recall. I mean, William may have asked me what my opinion was of where we've got to, but from then on, it was nothing to do with me, and I took no further part.
You have in part anticipated what my question was going to be. As far as you can recall, did you have any discussions with William Waldegrave?
Well, I'm sorry, I've anticipated and answered it yet. I can't remember having any discussions with William. Ask William.
If we go to then as the next document, JEVA.
I may have had discussions with William about the department, because he was taking on as all secretaries say, do a huge raft of problems in the department. But I doubt whether I discussed this. He'd find out in due course, and the lawyers would guide him rather than my. No point in my trying to bring him up to date and where we were in one of our cases of litigation, because the Department of Health has a lot of litigation on at any given time.
If we go to JEVA 5065, please, Shamik. This is an extract from the first edition, I think, of your book, of your autobiography, and I just want to ask you about the third paragraph, a change that was made to it. You say in the third paragraph in this version, the haemophiliacs who spent the rest of their lives with this disease were eventually given compensation by John Major's government. And then you go on to talk about the continuing campaign for more generous compensation for their suffering and to help them with the costs of their illness. As I understand it, Lord Clarke, concern was expressed to you about the use of the word compensation, because no compensation, no assessment of need. Or
I had lawyers. Publishers had lawyers' letters and so on. Though quite what legal action they were contemplating, we never discovered. I'm afraid the threat of legal action was a bit of a joke. But it is true. We collected it in the next. I dictated this. This autobiography is mine, and I dictated it into a dictaphone, and sessions. About twice a week, 2 or 3 hours at a time, with a little notes to make sure I kept some order and didn't leave things out. And it was a slip. In the serious terms and precise terms in which this inquiry and everything else had been conducted, I shouldn't have used compensation. I should have said ex gratia payments. And when it was drawn to our attention, we ignored the threat of legal action, but the publishers and I agreed that we'd change it in the next edition, and the lawyers accepted that and were content with that.
Now, I want to turn now to a separate issue. It's one that you address in your witness statement, paragraph 17.
I was writing that for the general leader. I was not giving evidence in a law court or before an inquiry, so I'm afraid it was just a slip to call it compensation.
If we just go to your witness statement, Lord Clarke, if we pick it up at page 13, you'll see a heading towards the bottom of the page, Lord Clarke, hepatitis C and screening tests. Now, just to place this part of your statement in context, an important issue for consideration coinciding with your time as Secretary of State was the question of whether there should be some form of testing, surrogate testing or screening testing in relation to hepatitis C.
Yes.
And the purpose of my questions is going to be to explore with you the extent to which, and it appears to be a very limited extent, those issues crossed your desk as Secretary of State for Health. So if we go to page 15, please, Shomek. And pick it up at paragraph 17.2. You say, first, I've been advised that, as the question indicates, there's a difference between surrogate testing of donated blood for hepatitis C and screening tests. The papers that I've been shown in relation to this issue during the period in which I was Secretary of State for Health focused on screening tests. And you say you're not in a position to explain what...
Yeah, I don't. I must admit, I must confess, I don't, still at this moment, don't wholly understand what a surrogate test is.
Okay, well,
that's a medical question, which you'll no doubt put to the medics.
Yes. So is it right to understand then, as far as you're aware, the question of surrogate testing was something that was never raised with you at all?
I don't remember it being raised with me, and I'd say, as it happens, I can then say, sitting here as I do now, I don't understand. I mean, someone would have to explain to me what surrogate testing is.
Now, in relation to the issue of screening tests, we can pick up, you say at the bottom of the page you've no independent memory of the issue. I'm just going to pick up with you the handful of documents that refer to it, that appear to have potentially come across ministerial desk, really just to try and understand the limited extent to which there was involvement by ministers in this issue.
Well, I won't repeat it again. It runs through all its evidence. I was not directly, it wasn't one of my responsibilities. I was not directly responsible for any of this. I only play such a prominent part in evidence because I'm nowadays have the misfortune to be slightly better known than any of the others, and I'm the nearest to a B-list celebrity you've got. I don't think I ever got immersed in testing for hepatitis C, but I was aware that the subject was being handled, but it was handled by whoever was doing blood products.
That may indeed be correct, Lord Clarke. The purpose of this is just to try and put out into the open, into the public domain.
Well, we've had 2.5 days of asking me detailed questions about things which I was never in charge of.
The purpose of these questions, Lord Clarke, is to examine the precise extent of your involvement, limited as it may be.
Okay, I'm sorry, I'll stop.
With an issue that you haven't been asked about.
I'll stop complaining about your question.
Thank you. WITN 0758019.
Because I say I have no independent memory of the subject at all. I'm entirely reliant on the documents, as you are.
That is understood. So we can see this is a minute dated the 19th of February 1990. We can see what's written on it in handwriting next to the CC. So it's CCPS to PSH, all private offices. So would it be right to understand that this would have gone to your private office, not necessarily, as you've already explained?
Yeah, it's obviously all the other ministers. I think Strawn, no, I'm not sure Strawn Heppel's mine. I'm not sure which of those. Anyway, yes, that would have all gone to all private offices.
Yes.
As I've said right at the beginning of my evidence, that doesn't mean every minister would have seen it.
Indeed.
Someone in the private office would decide it, would have taken a decision whether his or her boss ought to see this.
And we can see it's primarily addressed to Dr. Metters and then to the private secretary, to the Parliamentary Under-Secretary of State in the House of Lords. Headed Norne non B hepatitis.
Who was that by this time?
I think it might have been Baroness Hooper, but I'll have to double check.
Yeah,
This note seeks to bring ministers up to date on the current situation regarding testing for non-A, non-B hepatitis, often referred to as hepatitis C in donated blood. Ministers will be aware of the recent press interest in this topic and a number of parliamentary questions that have been raised consequently. We have the background. Since the middle of 1989, Ortho have been marketing a test as a method of identifying carriers of non-A, non-B hepatitis. And then there's reference a couple of lines further down to the Department's Advisory Committee on the Virological Safety of Blood, which I asked you about yesterday, Lord Clarke, discussed the possible routine use of the test in the National Blood Transfusion Service at its meetings in 1989, but decided that not enough was known about the meaning of the positive results that it produced, nor of its reliability. A pilot study using the Ortho test was initiated. We then see the current position set out in paragraph 3. At the January meeting of the Advisory Committee on the Virological Safety of Blood, members once again addressed the question of routine introduction of the test. The committee's decision was that there was still insufficient scientific information about the test to advise its routine introduction. And then there's a reference to an international hepatitis meeting, and paragraph 5 then says ministers will be kept informed of any further advice from the advisory.
This is obviously a note to make sure we were all up to speed with where we were.
Yes.
And no minister would have interfered with the expert advisory committee. It's entirely what they're there for.
So in terms of what you would have expected as a ministerial response to this from whoever the appropriate minister was, it would have been really simply to note it and await an update.
Well, it's in case, I'd say somebody like me and the Secretary of State, we were the ones, in those days, it's all more controlled. The government's going for message discipline nowadays. But in those days, we were constantly in the public eye because we were doing media interviews. I mean, it's part of our job, and defending the government against I did a lot of it. I mean, I think the Secretary of State sort of liked to shove me out there, which I didn't mind. So I'd be interviewed frequently, radio, television, newspapers, and you needed to be kept up to date with this because whatever you had been told you were going to be interviewed about when you accepted the invitation, once you were there, the interviewer, today's programme I used to do a lot, about twice a week, I'll bet, this time. Once you were there, they'd ask you a question or two about what they'd asked you to come in about, and then one just knew, if you've got the slightest sense, they'd ask you about anything that was in the department's field. That's one reason why you did have to be kept up to date with what was going on, because if they raised something that we weren't actually doing, I wouldn't sit on the Today programmes. I do to you, saying that's not my responsibility. You must, ask another minute. I would answer for the department. You had to keep up to speed, be aware at least of what was going on other fronts. Hence, to me and to the Secretary of State, this was usual because at any stage someone might shout a question at you or raise it in Parliament, and you'll be expected to give some sort of response on behalf of the department and the government.
If we go to what appears to be then the next update, it's at NHBT 5061_130. This is dated the 1st of May 1990. Again, it's to Dr. Metters and to the Private Office of the Parliamentary Under Secretary of State in the House of Lords. It's copied, sorry, if we just go to who it's CC to. It doesn't look from that, as I read it, that it was copied to your private office. Is that
No,
correct?
because I wasn't dealing with it.
No. No criticism implied in the question, Lord Clarke, a question of fact. And we can see, and I'm just drawing attention to this in light of some of the earlier questions I asked about interaction with the devolved administrations, it does appear to be copied to someone from the Scottish Home and Health Department, the Welsh office and the Northern Irish office. And then if we just look at the second paragraph, and then I'm going to ask you a question. Sorry, in fact, Seamus, can we just look at the first paragraph? My apologies. Minister may recall that the question whether to screen all blood donations for hepatitis C virus has been under discussion in the Advisory Committee on the Virological Safety of Blood. This note is to advise Minister of Developments. In France, Belgium, Luxembourg and Finland, screening has recently been introduced for all donations. And in Italy, the screening is voluntary. However, at its meeting on the 24th of April, our committee reaffirmed its view that the introduction of routine screening would not yet be justified. The new tests developed in the USA have not been approved by the FDA, and there are still unresolved difficulties concerning the tests. The committee has advised that a pilot study should be carried out to learn more about the significance of a positive reaction to the test and the extent to which it predicts infectivity which could be transmitted in blood. And then there's reference to a working party, another meeting of the ACVSB, and the department will be asked to provide funds for the study. Now, Lord Clarke, I'm conscious this didn't come to your private office. But my question is about what your expectation would be of the minister to whom this did go. Would you have expected the minister to, again, simply note that and await further updates, or to start challenging or asking questions?
Anybody with common sense would note it and wait for the next stage in this extremely expert committee's advice. That happens today. I mean, I won't start making comparisons with the COVID again. You don't start using vaccination until the immunologists and other scientists on your advisory committee confirm that it's safe and it works. And that's true today. It's true in any well-run healthcare system. It was true then. And the tests that we use for COVID today are the ones that have gone through the appropriate system. I'm sure there's another expert committee of virologists with an equally long acronym, which goes through the process, which unfortunately can take a few months, of getting the data and actually being confident and sure that firstly it works and makes a difference and gives you accurate results, and that it's safe. Now, no minister in their right mind interferes with that. You don't start second-guessing that. You don't say the Daily Mail said yesterday we were left behind. You wait until the virologists and the experts, who are amongst the best in the world, tell you this is now right. I mean, I don't know whether this would go to the licensing committee, safety of medicines committee, and all that kind of thing. There's a whole process. It's not political. It's not civil service government. It's scientific and it's medical. And in COVID, there are vaccines approved here which have gone through that process. We don't use some of the vaccines that other countries, China, Russia, use, which obviously our expert committees would, don't think they've gone through the full process that we expect before we start using anything of that kind. And I would expect the minister to note this, but not remotely to, unless something funny appeared to be happening in terms of process. The minister's got to wait, if he or she is being responsible, for the final advice of the advisory committee, which has been set up for the purpose of telling everybody where we are.
Vaccinations might not be said to be a particularly apt analogy, because this is not about giving treatment or a drug or a vaccination to patients.
It's testing.
It's about screening blood.
Well, in that case, I should have stuck to the test and trace system. We have various types of test we're using for COVID, and they've all gone through the same process.
It might also be
said... So
you're
quite right, I was inaccurate in talking about the vaccine. Tests for COVID.
It might
exactly the same system prevails today and does in every well-run, well-governed, sensible, developed country in the world.
It might be said that there are echoes here of what we explored yesterday in relation to the introduction of screening for HIV. In other words, other countries ahead of the UK in terms of the introduction of screening.
It might be said. I know you have to put these questions. It might be said, but frankly, I mean, let's go to COVID, test and tracing. The Chinese may be doing it differently. So do you say, the Department of Health is obviously negligent, let's do what the Chinese do? No, we don't do that. There's no point in our medics are some of the best in the world. We were amongst, I don't stupidly overdo it, we have amongst the best, we have the clinical standards in the world. The scientific expertise in some of these subjects, as it happens, virology is one where we're very, very strong. That hardly anybody's got a better system than us. So a journalist might say, we've been left behind, but that's not a responsible way to take the decision. And if it went wrong and you were before a public inquiry, if you told the counsel to the inquiry, we did it because Chinese were doing it, I'm afraid I don't think you'd get very far. I don't think you'd be treated with very great patience.
I take it, but perhaps you can confirm take it from your answer, Lord Clarke, that you are, and this implies no criticism, that you are unaware of the subsequent judgment of Mr. Justice Burton in the case of A and the National Blood Authority.
I am completely unaware. I've never heard of the
screening
case.
Should have been introduced.
I've never heard of the case. Are you about to tell me there is a case which is
there
exactly...
There is indeed.
What happened there? Well, tell me, now you tell me about it. Tell me what was said.
It's a very lengthy judgment. I'm very happy to provide you with my copy.
I'm sure you're anxious to save time, as you have been throughout. You're not going to tell me what it said. Or just hinting to me in a sinister way something said that you think contradicts what I've just said to you.
Lord Clarke, my question was whether you were aware of the judgment, and the answer is clearly
I'm
you were
not.
And Can we go back then to the question of what
if you wish to make anything of it, you better tell me what the judgment is.
May I just intervene gently in this discussion, this chat between the two of you? You were saying that it isn't the practice here, you make a big point, to rely on what other countries are doing, because we have perfectly good in fact, eminent doctors ourselves. Could we just have the document back, please, Shoemaker?
I mean, we inform ourselves of what other
Could we just have the
countries are doing.
section back? Thank you. If we just have a look at what was being said. I appreciate this document didn't come to you, but 5 lines down, in the second paragraph, the new tests developed in the USA have not been approved by the Food and Drugs Administration. That seems to be relying upon what the Americans were doing. You wouldn't have expected that, would you?
Well, it's relevant if it's not been approved by the FDA. Probably explains why it's not been approved by ours either.
So this was, in part, at any rate, relying, or
in the end, I
on
think 99, more than that, out of 100. In the end, we rely on we set up we have our own licensing, our own safety of medicine system, our own advisory committees, and we rely on them.
And your point is that,
although of course you keep yourself informed of where we are in other, like these countries as are cited here, comparable countries that also have excellent healthcare systems.
Thank you.
If we just move to the next update, I'm just going to draw it to your attention before I ask you a question about the document after, if I may, but so that no one suggests that I'm not showing you the material or Clarke NHBT 5061_137. This is dated the 11th of May 1990. This does go to your office. We can see that from the top left-hand corner. Hepatitis and blood products. It refers to the press carrying 2 stories about hepatitis and blood products.
But it's actually, yes, I was Secretary of State, so it's gone to me, this.
It has. It is predominantly dealing with a suspect hepatitis B contamination at the Bioproducts Laboratory, as BPL was now called. I'm not asking you about that. If we go over the page.
This is the one where I was annoyed because the Blood Products Laboratory hadn't told us.
Yes.
And we found out about this slip through the newspapers.
That is indeed the one. If we look at paragraphs 5 and 6, we can see reference then to a Lancet article on hepatitis C. This shows high rates, as expected, high rates of positivity with a recently developed test for hepatitis C in recipients of blood products. Before heat treatment of blood products was instituted in 1985, transmission of non-A non-B hepatitis to haemophiliacs was commonplace, and these findings reflect past infections. And then it talks about heat treatment through NHS 8Y, factor 8. And then paragraph 6 continues, but there remains the question of whether the National Blood Transfusion Service should, as an additional measure, screen donations for hepatitis C to protect transfusion recipients. This is now being done in Japan, Belgium, Luxembourg, Finland, and very recently in the USA. The Department's Advisory Committee on the Virological Safety of Blood under Dr. Metters have been considering the available evidence, in particular on the significance of a positive with this new test. The committee recommend further work on UK donors before a decision can be made. And then we have a line to take. The first is in relation to the BPL hepatitis B issue, and then the second is on hepatitis C. So this is your suggested line to take. The line to take suggested to you. The department considers that there is at present insufficient scientific information about this test. The matter of testing blood donations for hepatitis C is being kept under review. Lord Clarke, given, as you've told us on a number of occasions, you regarded it as part of the responsibility of a minister to challenge, to test the advice that you're being given, whether by experts or otherwise. Do you think at this point in time, knowing that now the States was using testing as well as the other first world countries there identified, that you would have wanted to understand, if this had actually come across your desk and not just reached your private office, why the UK was not yet introducing the test?
Well, it explains why, because we have an advisory committee which doesn't think we should.
So you'd have just accepted that, do you think, and not probed
I assume
further?
I did. When I say you challenge, that doesn't mean you spend every time you get a clinical opinion from the world's experts, you say, I wish to challenge this. Tell me why other people are doing something different from us. Occasionally, I mean, sometimes medical opinions merge with also the administrative decisions and so on, which you can feel some confidence on. But, I don't, 9 times out of 10, there's no point in a non-clinician with no expertise on the subject at all spending his entire time challenging, cross-examining the experts who are giving you advice.
And then if we go to the final document to show you on this subject, NHBT 0...
how did it turn out? Were they wrong?
Well, that's for the chair to determine.
Well, one thing is confirmed is so far as haemophiliacs are concerned, I accept you're considering infected blood as a whole. The problem had largely been solved 5 years before, as I've said several times throughout this. It was heat treatment that solved it in the end. Obviously, it's relevant to explore all the things we're exploring, but what turned out to save such haemophiliacs not infected from further infections, what turned out to make even American factor 8 safe was heat treatment. And that we were doing that from 1985 onwards, and this is several years later.
Have you ever been aware, Lord Clarke, that thousands of people, precise numbers hopefully to be established, or some greater degree of precision to be established in due course, were infected with hepatitis C through blood transfusions?
It's a risk still with blood transfusions, as though they do, because we test nowadays. Hepatitis C continues to this day to be, I think, again, I speak as a layman. These questions are all best put to some medic. But my understanding is hepatitis C remains something you have to be very aware of in hospitals today.
And then if we look at the final document, NHBT 40189_201, please, Shomek. This is dated the 7th of August 1990. It appears from the left-hand top of the page, it's going to the private office of the Parliamentary Under-Secretary of State in the House of Lords, and not, I think, if we look at who it's copied to your office. Does that look right?
Yeah, because she was dealing with it.
And then we will see it says PSL to the Parliamentary Under-Secretary of State in the House of Lords will wish to know that at its July meeting, the ACVSB advised in principle that all blood donations should be screened for hepatitis C virus. A full submission setting out the case for screening, the financial implications and results of a cost-benefit study will be provided shortly. As a first step, the ACVSB has recommended a pilot study to evaluate the 2 available screening tests and the supplementary tests which will be used to discriminate between infectious and non-infectious positive reactions. To the initial screening test, this would give the NBTS experience of using the tests together and would indicate if there are particular advantages in using one or other of the initial screening tests. Preparations for the evaluation are underway and the results are expected to be available in October for consideration by the ACVSB. The screening of blood donations would cost an estimated £5 to £6 million a year. The question of how this would be funded will have to be considered in the full submission. Now, again, Lord Clarke, I am conscious in asking this question that there's no evidence to suggest that this came to your attention.
I have nothing to do with this.
So my question is a more general one. Would you have expected the Parliamentary Under-Secretary of State, so the Minister who was dealing with this and sent this, again, simply to note this and await a further update, or to start asking questions now that we have both evidence from abroad and the ACVSB, as to whether things could be done more quickly?
I'll sit here and off the cuff advised how I think the Parliamentary Under-Secretary of State, the Lords, should have reacted to a document which I've never seen in my life before. I'm not going to give some instant, firm authoritative view. I can't see anything wrong with the submission. Seems to speak for itself. It's all frightfully clear. If it had come to me, I suspect I would put on content or noted, signed it, Ken, and moved on to the next document in the box.
But just to say, look, like you say, a document you've never seen before, it is actually referred to in your witness statement.
Oh, well, it shows somebody helping me put the witness together pointed out to me and I'd forgotten it. I'm sorry, it's the second time I've seen it in my life.
And then you say in your witness statement, and I don't have a question, Lord Clarke, I just want to correct something as a matter of record. You say in your witness statement, I've been informed that a ministerial submission was eventually sent in December 1990, after I'd left the Department of Health. So my current understanding, but we'll check this and pick this up with other witnesses or through presentations as appropriate, is that it was January 1991 that the submission referred to was sent. But we'll double check that. And it's right that decisions were then taken after Lord Clarke left office, so I'm not going to ask any further questions about that issue.
I'm sorry, I'm so exasperated, but this whole inquiry started with newspapers reporting me and attacking me for decisions taken a long time after I'd left office. So nothing to do with me at all.
So I note the time. I've got a very, very small number of my own questions left, and then a larger number of questions suggested by core participants to field and advance. So if we could take a break now, that would be good.
Yes, well, we'll take a break until 10 to 12, shall we?
Thank you.
10 to 12.